because you have decided how you want your estate to be handled, and you have determined who is to benefit from your estate. When you drafted your will, you told the attorney who you wanted to be executor. The executor is just a formal name for the person in charge of making sure that what you said in your will be followed. In Kentucky, if you do not have a will, that person is referred to as an administrator, but they are essentially people doing the same thing, carrying out the requirements under your will if they're an executor, and by law if they are the administrator. The executor files a petition with court attaching your will and listing all of the assets that you owned at the time of your death as well as your debts. Then the court has a hearing on the will, and it asks the witnesses who have witnessed the deceased person's signature on the will to come forward to court and to testify that at the time the person making out the will, whom Irene referred to as the testator, was over the age of 18 and of sound mind and body. These witnesses, by signing their name to this document, further swear that they saw you sign, the deceased person, sign the will at the time that they made their signatures as witnesses, and they, in their presence, in the presence of the person who died, signed their names also to the will. If this procedure was properly followed, then the court can then admit the will to probate and will officially appoint the person named in the will as executor to carry out the terms of the will. The executor signs a bond with the court, whereby he or she promises to faithfully carry out their duties as executor. And depending again upon the terms of the will, they have to post money or property as surety on that bond. The person making out the will can decide if they want the executor to have to do this and how much money or property they would feel comfortable with as surety for the bond. Once the executor is appointed, the executor's responsibility is to go out and collect the assets, pay the debts, and account to the beneficiaries as to how this was done. The executor is required to file with the court within 60 days after his or her appointment a list or an inventory of what is in the estate. Then, at a period not less than 6 months, the executor must file what's called a final settlement, whereby the executor tells the judge exactly those assets that have been collected and those debts that have been paid. And he outlines for the judge what is going to be done with the balance, how those funds or that property is to be distributed to the beneficiaries that are set out in the will. Under Kentucky law, an estate must remain open a minimum of 6 months. This is done for the protection of the creditors or the persons to whom debts are owed. When an executor is appointed, a notice is placed in the newspaper advising anyone who has a claim against the estate, who has a bill that needs to be paid, to present it to the executor. If it's not presented within this 6-month time period, then the beneficiaries or heirs of the will cannot be called upon to pay these debts. The executor, however, must account to the court as to how each of these bills are paid when a claim is presented. If all the claims have been paid and all the business of the estate has been wrapped up within the 6-month period, then when that 6 months has expired, the executor can file a final settlement with the court. The beneficiaries, however, do not receive their share of the settlement until the court has reviewed that final settlement. It's been advertised in the local newspaper in case anyone has an objection to the settlement, and the judge has signed an order approving the closing of the estate. Now, one of the responsibilities of the executor that often causes the beneficiaries to be consulted with and to be advised about is the payment of inheritance taxes. And we've talked briefly about that this afternoon. In Kentucky, if a spouse receives everything in the estate from the other spouse, there is no inheritance and estate tax. So essentially, after filing some forms with the Department of Revenue, the surviving spouse receives everything tax-free. That's not the case, though, for other beneficiaries. Under Kentucky law, as it presently stands, a minor child receives a $20,000 exemption. Anything over $20,000, the minor child must pay inheritance tax on. An adult child has a lesser exemption and only receives a $5,000 exemption. Anything an adult child then receives over $5,000, they must pay inheritance tax. Other beneficiaries of lesser relation to the person who died, such as a niece or nephew, only have a $1,000 exemption under the law, and persons who are not related at all have only a $500 exemption. Federal estate tax only applies to estates in excess of $600,000. Now, while that may seem to be a very large amount, if one sits down and adds up all of the things that they own at the time that they die, you very quickly see that $600,000 can be accumulated very quickly. If you add up your house, possibly a family farm in which you have an interest, you look at your retirement plans, your IRAs, you consider life insurance that you may have payable to the estate, your bank accounts, stocks, bonds, savings, those items add up very quickly. And some people who may not think they have a federal estate suddenly discover that by adding all that they've accumulated during their lifetime, they come